The envelope was cream-colored with the court seal in the upper left corner. I had been expecting it for 11 days, not because I had inside knowledge of the legal process, but because the specific sequence of events that had been unfolding across the previous 3 months had the particular trajectory of something building toward a document exactly like this one. When you have spent 8 years as a forensic accountant, you learn to read trajectories the way other people read weather. You feel the pressure changing before the storm arrives. My name is Simone. I am 37 years old. The summons told me I was being named as a defendant in a civil suit brought by my parents-in-law, Raymond and Doris Whitfield, who were alleging that I had been complicit in, and had financially benefited from, the collapse of a business enterprise operated by their son, my husband Calvin, and that I owed them and the business's creditors a sum that the document described in numbers I will not repeat here because numbers extracted from the context of what produced them are only partially honest. I set the envelope on my kitchen table. I poured coffee. I sat down. I thought about what I had been doing for the previous 11 days, not waiting, not worrying, building. The specific careful building of someone who had known the document was coming and who had used the 11 days to ensure that when it arrived she was in a position to respond to it with complete accuracy. Calvin and I had separated 9 months ago. The business, a restaurant group he had been developing across 4 years with the particular ambitious energy of a man who had a large vision and the specific difficulty of someone who could not match the vision scale with the operational precision that the scale required, had collapsed 8 months ago. The collapse had left creditors. It had left Raymond and Doris's investment of $200,000. It had also left a paper trail. I had been following the paper trail since month 3 of the business's operation, when I had first noticed the specific accounting anomalies that told me the business was not being run the way Calvin was describing it to his parents and to me. I picked up my phone. I called Adrian. The paper trail had begun on a Tuesday morning in month 3 of the restaurant group's operation. I want to tell you about the beginning because the beginning is the story, not the courtroom, not the summons, but the specific Tuesday morning when I looked at a set of accounts that my husband had asked me to review because he had said, with the particular casual trust of a man who considers his spouse's expertise a convenient household resource, that the bookkeeper had made some errors and that my professional eye would catch them faster than anyone else. He had been right that I would catch them. He had been wrong about what I would catch. The errors were not bookkeeping errors. They were the specific kind of accounting irregularities that 8 years of forensic work had trained me to identify. The particular pattern of transactions that are not random mistakes, but that follow the logic of someone who is moving money in ways that are not reflected in the official financial picture. I had looked at those accounts for 4 hours. I had made copies. I had made copies not from suspicion, from the particular professional reflex of someone who understands that financial documentation has a specific shelf life and that the documentation of an anomaly is only useful if it is preserved from the moment of its discovery. I had stored the copies in a folder. I had continued looking every month. Over the following 12 months, I had assembled the specific complete picture of what was happening in the business, not with the emotional investment of a wife who is betrayed, but with the professional precision of a forensic accountant who was documenting a financial pattern because financial patterns that are not documented cannot be accurately understood by anyone who is not present when they were occurring. What the pattern showed was this. The business had been receiving investment from Raymond and Doris, from 2 external investors, from a business development loan. The money was coming in. A portion of the money was also going out through channels that were not reflected in the business's reported expenses. Not a large portion, but a consistent one. Monthly. Beginning in month 2 and continuing through month 14 of the 16 months before the collapse. I had not confronted Calvin. I had documented. I had continued documenting until the separation. The folder contained 22 months of documentation. The folder was in the file cabinet in my home office. The folder was going to court. Adrian Cole was 44 years old, African American, and had been practicing commercial and financial litigation for 18 years with the particular sharp-edged intelligence of a woman who had built her reputation entirely on the quality of her preparation. On the specific understanding that a courtroom is not the place where cases are won but where cases that were already won in the preparation room are confirmed. She had been recommended to me by a colleague 3 months before the summons arrived. I had retained her 3 months before the summons arrived. Not after. Before. Because I had known the document was coming and because the 11 days between the last thing I had observed and the arrival of the cream-colored envelope were not enough time to prepare the response that the situation required and because I had spent 8 years understanding that the people who are most protected in legal situations are the ones who had attorneys before they needed them. Adrian answered on the second ring. Simone, she said. It arrived, I said. When? She said. This morning, I said. Bring it in this afternoon, she said. I have a 4 o'clock. I drove to her office at 3:30. Her office was on the 9th floor of a building downtown, not the most impressive building, not the most prominent floor, but the specific kind of space that communicates through its organization and its shelves of well-used documents that the work done here is serious and that seriousness is the organizing principle. I set the summons on her desk. She read it. She set it down. They've named you specifically as a defendant, she said. Yes, I said. They're alleging complicity and financial benefit, she said. Yes, I said. What is your documentation of the actual financial picture, she said. I set the folder on her desk. 22 months of documented transactions. Bank statements. Copies of the original accounts. The anomaly log I had been maintaining. The specific complete record of what I had observed and when. She looked at the folder. She opened it. She read for 12 minutes without speaking. When she finished, she set it down. She looked at me. Simone, she said. Yes, I said. They brought this action without knowing what you have, she said. Yes, I said. That was a significant error, she said. I know, I said. She almost smiled. She had been doing this for 18 years. She did not smile easily. The almost was significant. I had known about the money for 18 months before the collapse. I want to be specific about what knowing meant and what I had done with the knowing, because the story requires honesty about the specific difficult position of a woman who is also a professional and who is married to the person whose financial behavior she has documented and who must decide what to do with the documentation before the situation has required her to do anything with it. I had told Calvin. Not immediately. Not in month 3 when I first saw the anomalies. I had told him in month 7, after I had confirmed that what I was seeing was not a pattern that could be explained by legitimate business operations that I was misreading. I had sat across from him at our kitchen table. I had set the folder in front of him. I had said, "Tell me what this is." He had looked at the folder. He had not looked surprised. He had looked the way a man looks when he has been found and who has been preparing for the finding for some time and who is now in the specific moment of deciding what to do inside the finding. He had said, "It's complicated." I had said, "I need it to not be complicated. I need it to be accurate." He had told me. The money was going to a separate account. Not to a hidden life, not to the things that people sometimes imagine when they hear about money being moved to separate accounts. It was going to cover losses in the business that Calvin had been covering personally rather than disclosing to his investors, including his parents, because disclosing the losses would have required him to admit that the business was not performing the way he had projected. He had been managing the losses by absorbing them himself. He had been doing this by moving money from the business. It was not embezzlement in the simple sense. It was the specific, complicated kind of financial mismanagement that occurs when a man who cannot admit failure to his parents tries to protect an appearance that has already diverged significantly from reality. I had told him, "This cannot continue." He had said, "I know." It had continued for 7 more months before the collapse. I had continued documenting. Raymond Whitfield was 67 years old and had the particular quality of a man who had built his self-image around his son and who experienced Calvin's failures as attacks on that image rather than as circumstances to be addressed. Doris was 64 and had the specific quality of a woman who had always expressed her love for Calvin through the particular management of the obstacles in his path, which meant that when an obstacle presented itself, she organized herself and her husband against it with the focused energy of someone who had been doing this for 40 years and who had not yet encountered an obstacle that had not yielded to the application of sufficient force. I was the obstacle. They had invested $200,000 in the restaurant group. They had lost the $200,000 when the restaurant group collapsed. They had been told by Calvin, and I want to be precise about this because what Calvin told them is the foundation of the legal action they brought. That the collapse had been caused by financial mismanagement that had occurred during a period when I had been involved in the business's accounting. Calvin had told them this. He had not told them the complete picture. He had told them the part that directed attention toward me. I want to say something about Calvin that the story requires me to say honestly. He had not done this from calculated malice. He had done it from the specific desperate positioning of a man who was facing his parents' grief over $200,000 and who had, in the specific moment of being asked to account for the loss, directed their attention toward the explanation that was simultaneously true in a narrow sense and deeply misleading in the complete one. I had been involved in the accounting. I had been documenting the anomalies in the accounting. I had not been causing them. Those are different things. I had 22 months of documentation showing exactly which one I had been doing. Adrian had reviewed the documentation. She had said the action would not survive contact with the evidence. She had also said something else. Simone, she had said, the evidence doesn't only clear you. It tells a different story about who caused the collapse. I know, I had said. Are you prepared for that story to be told? She had said. I had thought about 22 months of documentation. Yes, I had said. The hearing was at 9 a.m. on a Thursday in April. I want to describe the morning because mornings before significant legal proceedings have a specific quality that is different from other mornings. The particular weight of a day that has been coming for a long time and that has finally arrived and that requires everything you have in a way that ordinary days do not. I woke at 5:30. I made coffee. I sat at the kitchen table for 45 minutes in the particular quiet of an early April morning that had not yet committed to weather. I was not reviewing documents. I had reviewed the documents. Adrian had reviewed the documents. The documents were in the portfolio that Adrian would carry into the courtroom. There was nothing left to review. I was sitting with the specific quality of a woman who is prepared completely and who understands that the preparation is done and that what remains is the execution and that the execution requires a particular kind of stillness before it begins. I thought about my grandmother. She had been a bookkeeper for 30 years, not a forensic accountant, the simpler and more essential work of someone who keeps accurate records because accurate records are the foundation of everything that is honest about money. She had taught me to read financial documents when I was 12 years old. Not as a lesson, as the ordinary sharing of someone who loves their work and who sees in the person sitting beside them a mind that is ready to receive it. She had said, Simone, the numbers never lie. People lie about the numbers. But the numbers themselves, if you read them carefully enough, will always tell you the true thing. I had been reading the numbers carefully for 8 years. The numbers had been telling the true thing for 22 months. Today the numbers were going to speak in a courtroom. I dressed. I chose with the particular deliberate intention of someone who understands that how you present yourself in a significant room communicates something before you have said a word. I drove to Adrienne's office. We drove to the courthouse together. She carried the portfolio. I carried my grandmother's lesson. The courtroom was the specific functional dignity of a civil court that has been processing disputes for 40 years, clean lines, flat light, the particular atmosphere of a space that is professionally neutral about the human situations that pass through it. Raymond and Doris were already seated. They had an attorney, a man I had not previously encountered who had the particular quality of someone who has been given a case to argue without being given the complete picture of what the case contains. He was going to discover the complete picture this morning. Adrian and I sat at the respondent's table. She set the portfolio on the table. She opened it without drama. The judge, a woman of approximately 55, who had the particular settled efficiency of someone who has been doing this for a long time and who has developed the specific quality of attention that allows her to read a courtroom quickly, called the proceeding to order. Raymond and Doris's attorney made the opening statement. He described the investment, the collapse, the allegations of complicity, the claim for damages. He described me as the person who had been involved in the business's accounting and who had failed to prevent the financial mismanagement that caused the collapse. He was right that I had been involved. He was wrong about everything else. Adrian stood. She did not raise her voice. She had the particular professional quality of someone for whom volume is never the instrument, clarity is always the instrument. She said, "Your Honor, the respondent has in her possession 22 months of documented financial records from the business in question. These records include the original accounts, a documented log of financial anomalies, bank statements showing the movement of funds, and correspondence in which the respondent directly notified the business's principal operator of the anomalies and requested corrective action." The judge looked at the portfolio. "She documented the problem," Adrian said. "She did not cause it." Raymond looked at Doris. Doris looked at their attorney. Their attorney looked at the portfolio with the specific expression of a man who has just understood that the case he was hired to argue has a dimension he was not told about. The judge said, "I'll review the documentation." She reviewed it for 14 minutes. When she looked up, her face carried the particular settled quality of a judge who has arrived at a clear understanding and who is now going to communicate it. The judge spoke for 11 minutes. "I want to tell you what she said, not by reproducing her legal language, but by telling you what the 11 minutes meant in the specific human terms of what it is to be in a room where something that was designed to take from you is reorganized by the truth into something that takes nothing." She said that the documentation presented by the respondent was extensive, organized, and dated in ways that established clearly the sequence of events, that the anomalies had been identified before the collapse, that the respondent had documented them continuously, and that the respondent had notified the business's principal operator. She said that the claim of complicity was not supported by the evidence, that the opposite was supported by the evidence, that the respondent had done what a professional in her position was expected to do, which was to identify and document a financial problem and to communicate it to the responsible party. She said that the documentation raised questions about the business's operation that were outside the scope of the current action, but that were relevant to the creditor's claims, and that she was referring the documentation to the appropriate authorities for review. She dismissed the action against me. The room was quiet for a moment in the specific way of rooms in which something significant has just happened and that are processing the significance. Raymond Whitfield looked at the table. Doris Whitfield looked at her hands. Their attorney was writing something quickly. Adrian gathered the portfolio. She did not look triumphant. She looked exactly as she always looked, composed, organized, and professionally complete. We walked out of the courtroom. In the hallway, Adrian said, "Are you all right?" "Yes," I said. "The referral to the authorities," she said. "You understand what that means?" "Yes," I said. The documentation I had been building for 22 months was now in the hands of people who would use it to determine whether the financial pattern it revealed rose to the level of something that required formal investigation. This was not my decision. It had never been my decision. I had documented accurately. The accurate documentation had gone where accurate documentation goes. "What do you need?" Adrian said. "A coffee," I said. "Done," she said. We walked out of the building into the April morning. The months after the hearing were the particular months that follow when a significant legal proceeding has resolved and when the resolution has produced consequences that extend beyond the proceeding itself. The referral to the authorities produced an investigation. I will not describe the investigation in detail because the investigation is not my story to tell. It belongs to the people whose actions it was investigating and to the process that was designed to address those actions. What I will say is that the investigation confirmed the pattern the documentation had described and that the consequences that followed were the specific consequences appropriate to confirmed findings. Calvin and I finalized our divorce in June. It was handled with the particular fairness of two people who were exhausted by everything that had happened and who had retained attorneys who were more interested in resolution than in prolonged conflict. What was mine was mine. What was jointly held was divided. The process was not easy and it was not quick, but it was honest, and the honest accounting of a marriage's assets is the only kind that produces an ending that both people can actually move from. Raymond called me in August. I answered. He said, "I want to understand what you did." I said, "What do you mean?" "The documentation," he said. "When you knew what you did with it." "I want to understand it." I told him. The Tuesday morning. The copies. The folder. The conversation with Calvin in month 7. The 7 more months of documentation. The separation. The 3 months before the summons. Adrian. He was quiet for a long time. You told him, he said. In month 7, I said. I sat across from him, and I put the folder in front of him, and I told him what I had found. And he didn't stop, he said. No, I said. He was quiet again. We didn't know, he said. I know you didn't, I said. We lost $200,000, he said. I know, I said. We were angry, he said. And we were given a direction for the anger. Yes, I said. I'm sorry, he said. I sat with this. I know, I said. Is there anything, he started. Raymond, I said. There isn't anything. The process is the process. The documentation said what it said. I'm all right. He said goodbye. I believed the sorrow in his voice. Here is what I kept from a cream-colored envelope and a 22-month folder and a courtroom on a Thursday in April and everything that followed. I kept my grandmother's lesson. The numbers never lie. People lie about the numbers. But the numbers themselves, if you read them carefully enough, will always tell you the true thing. I have built 8 years of professional life on this lesson, and I built my defense on it, and I walked into a courtroom carrying it, and the courtroom confirmed it. There is no professional principle I hold more completely. It is the foundation of everything I do with accuracy and the reason I started the documentation in month 3 when a different person might have chosen to look away. I kept the documentation practice. Not the specific 22 months, those served their purpose and are now in the appropriate hands. The practice itself. The specific daily discipline of creating an accurate record of what you observe at the moment you observe it, without waiting to understand its full significance. Because the significance of financial information is almost never fully visible in the moment, and because the documentation done in the moment is the only documentation that will be believed in a courtroom or anywhere else that requires evidence. I apply this now to everything important, not from paranoia, but from the professional understanding that the accurate record of what happened is the most durable truth available. I kept Adrian. She is my attorney for life. She carried the portfolio into the courtroom. She opened it without drama. She spoke without raising her voice. She said, she documented the problem. She did not cause it. 11 words. 18 years of preparation behind them. She is the specific kind of professional that every person should have access to and that too few people find before they need them. I had found her before I needed her. I will not take that for granted. I kept the coffee in the April morning outside the courthouse. Adrian and I sat at a table and drank it and said very little, and the April morning did its April things around us, and the courtroom was behind us, and what was in front of us was simply the rest of the day, which was simply the beginning of the rest of everything else. I am 37 years old. My in-laws brought me before a judge. I walked in with a folder. The folder said the true thing. The judge heard it. The numbers never lied. They never do. If this story reached something in you, if you have ever walked into a room designed to diminish you and walked out with the truth on your side, I want to hear about it in the comments. What did you document that protected you when you needed protection? Stories like this one stay alive because people carry them forward. Share this with someone who needs it today. And if you would like more stories told honestly, the way things worth keeping deserve to be told, subscribe. We will be here. The end.